All right. Hello, everybody. Welcome to the Monday Night Live stream with Matterhorn Business Development. I am not joined, as always, by Dr. Greg Winterig tonight. Tonight, I have a very special guest. We have Ashly Guernaccini. She is a employment attorney. I mean, you're a number of different things. How would I introduce you properly?
Yeah, employment's fine. I do just business law, business transaction, and often encompasses employment law all the time. So that's totally fine.
Okay, good. So all around business knowledge, business information, etc. And the reason that we have Ashly in tonight is because the topics of AB5 and the PRO Act keep coming up on our channel. The PRO Act is a Protecting the Right to Organize Act that is being introduced through the government to, obviously people want to get it passed. And we're a little bit concerned about that here at Matterhorn Business Development because we've seen a bill in California called AB5, Assembly Bill 5, that was introduced that just wrecked the independent market and the ability for people to be independent contractors and freelancers in the state of California. And when I heard about the PRO Act coming around, it concerned me because some of the language is AB5 reminiscent. And seeing the effects of AB5, it concerned me that the PRO Act would try to introduce similar things. And we've made several videos about this. And just for quick background for everybody, when we first did our first AB5 video, it was part of a Newsroom series that we filmed like 18 months ago or something like that. We did it because we thought it sounded pretty dumb. We put it up there. Nobody watched it. And then when the bill was introduced and actually enacted, our views went through the roof because people were pissed off. And then we had all the people yelling at us, telling us that we're stupid. And then we got real life stories that people were actually emailing to us to tell us how AB5 affected their business. And they shut down their business. They couldn't work and take care of their sick husband like they used to because now they're not allowed to freelance. And so we kept talking about AB5. And I have gotten a lot of extremely disgusting comments from people as a result of just me speaking my mind. So then I started speaking my mind about this PRO Act, and everybody said I was wrong. And I said, you know what? If I'm wrong, why don't we talk to an attorney who practiced in California, is still licensed in California, and has actually dealt with businesses through AB5, and now actually did research about the PRO Act, and we're going to kind of talk about that. And I'll just be upfront with everybody before I introduce Ashly. We only have 45 minutes tonight. Ashly's got another engagement that she has to get to. So if we're still going up for 45 minutes, we're going to end off and we're going to do a part 2. So hit the notification bell. It might not necessarily just be next Monday's live stream. It might be during the week. Who knows? So hit the notification bell and subscribe to make sure that you don't miss it. So Ashly, go ahead. I've talked for 3.5 minutes now. Tell us who you are and what your experience has been with AB5, et cetera, and then we'll start getting into the PRO Act and all that.
All right. Yeah. So my name is Ashly Guernaccini. One minor correction. I'm not licensed in California. Okay. Yeah. I was working, though, for about a decade as a registered in-house counsel for 2 different corporations in California. And I was working there when AB5 was being introduced. I saw the effect that it had on the business I was working for. So definitely familiar with AB5 in that Perfect. Aspect. I'm currently licensed in both Pennsylvania and Florida. And quite frankly, as you're bringing up the PRO Act, it's something that all states kind of have to have attention on, because should it pass, especially in relation to AB5, right, then we're talking about taking this California standard and making it go national, right? So it's something that I feel like any attorney in any state that practices any type of labor law, or even kind of touches on that in their practice, of course, needs to be well versed in the ramifications of the PRO Act and also know what's been going on in California with AB5. That being said, I do business law, so that's my introduction. I've been doing that for over a decade as in-house for corporations. Now I have my own firm, and I have the pleasure now of working with many different size companies and small businesses and larger businesses alike. And we definitely don't exist in a vacuum or fishbowl. So it's interesting for me to now get feedback from various clients of various size businesses on how these types of laws and these changes to, what is or what isn't considered an independent contractor. Do we unionize? What happens if we unionize? All these are sort of very hot topics for many businesses, small and large alike.
Yeah, and the reason that we talk about it on our channel is because there wasn't a lot of content being put out there about AB5 before it was passed, and there really wasn't a lot of people talking about it. And so it was kind of like there was a vacuum of data and information. And when I did our first video about the PRO Act last year and I read about it, I was scared and I tried to research it. And all I got was one viewpoint of information about how great it is. And I couldn't find anybody else talking about it. And that's why here at Matterhorn Business Development, we believe in businesses being able to be in control of their own future. We believe that people have the right to work for or not work for whichever company they want to work for. You have the ability to control your own future. And the more legislation that gets passed, the more the business owner is restricted, the less likely they are to hire people, the less likely they are to be successful. And so we are here, and I am talking about this because I believe in educating people on what these acts are and how they affect businesses, because it's very good and easy to say, yes, Amazon should be paying more in taxes. Amazon should do this for the employees. But if you pass a bill to attack Amazon, you hurt the small business owner that actually is the backbone of the society. And that's why we're talking about it here. So what would you like to start off with, or where do you want to go with what you've discovered or talked about with regards to AB5 or the PRO Act?
Well, I think, you made a good point about the differences in the business. And I think even just in legislation in general, oftentimes what we see is the aftermath of the bill often ends up creating the exact evil it was designed to prevent, right? And it's unfortunate because, there isn't a one size fits all. What is good for Amazon isn't going to be good for Joe's Pizza Shack down the road, and Joe has 3 employees, and he's just doing all he can just to get by and barely squeezing out a profit. So obviously the laws that need to be passed to help Joe are going to be slightly different than Amazon, right? And that's just the world that we live in. And unfortunately, when legislation seeks to attack a singular evil or what they perceive to be a growing evil, especially in these monopoly type businesses, there are these really unfortunate waves that trickle down to individuals and small business owners, and quite frankly, the working class oftentimes ends up suffering some backlash. And I think it's most notable in instances where, I think we can all agree, I don't think anyone's going to argue that workers deserve to be paid a fair wage. I mean, of course, everyone deserves to be paid a fair wage. Workers deserve benefits. Like, I think that there's, you can be pro-worker, right, and really want what's best for the worker without also being anti-business. And unfortunately, what happens when you pass legislation that's aimed at killing a certain evil or really going after it, you end up kind of getting all these things in the periphery that get caught into it that end up creating a lot of harm, or oftentimes the same harm that they were trying to prevent in small businesses. Like you fight for a higher wage, then that may happen, and employers are going to be, give out a higher wage if they're ordered to do it, or minimum wage increases, or if they unionize and they have to give a higher wage, they're going to do it. But then you also have to look at the expense. Sometimes that means they drop certain positions. People lose jobs that way. So I guess the whole point is, I think that you really have to be able to look at the full picture, right? And be able to see where sometimes things really do help, but then also sometimes when they go a little bit too far and end up working the reverse effect.
Yeah, exactly. So with the PRO Act, it's called Protecting the Right to Organize Act. What exactly does that mean? And how does that affect states where, because I know there's certain states that don't have the organized clause, so to speak. I don't know the right legal term for that.
Right, the right to work. There's 27 states that, that don't have, they have that right. Exactly. They don't have to organize. Yeah.
Correct. So what is the right to organize, and how does this bill start to go after that?
Yeah, so basically, there's definitely been a decline in unions, in general over the past several years, and with the new administration coming in, it's been made very clear that they definitely want workers to have that right solidly, to be able to organize, to be able to engage in the collective bargaining process. And I think the belief is, by some, at least now, that the employers have a little more leverage than unions as far as when it comes to speaking to their employees and maybe getting them to see that maybe they shouldn't unionize, or providing them with other information, right? And so the PRO Act is really pushing the pendulum way far in the other direction, right? Whereas, maybe there's a balance, or maybe it's a little bit more employer oriented now. Should the PRO Act pass, it will become very union friendly, right? Whereas employers are basically, sorry, my dog, essentially losing their voice in a lot of things. And not only employers, but employees as well. I'll give you one example. Like right now, when employees decide whether they want to unionize or not, it's typically done through a secret ballot process. And that being so, it remains confidential. And employees, their information doesn't have to be given out to unions, and it's not really known who votes yay, who votes nay. Well, part of this act, the unions can question whether or not the vote actually was how it was supposed to be, and they could start looking at these cards. They're no longer secret ballots anymore. So even something just like that, where an employee would normally have confidentiality, under this act, they would, in order to kind of gain more rights to unionize, they're giving up some confidentiality rights. So that's another example.
That's interesting, because if I don't want to unionize, I could be seen as being the stop behind the union.
Exactly.
And I could be targeted in different ways. Yes. That's interesting.
So that's where you see that kind of reverse pendulum swing, right? Whereas now you have employees that could potentially say, they don't want to be in trouble, get retaliated against for being a whistleblower for certain things against their employer. Well, you can easily see that happening with unions as well, where, just like you said, it can get exposed that a certain person or a certain group of individuals didn't want to unionize in this big company when other people did, and then they could get targeted, and they could get retaliated against because nobody's immune to it. Another example we discussed briefly before I came on is collective bargaining can sometimes be great, and as stated before, we do want people to get benefits. We want them to get better pay, but oftentimes the minimum wage increases for kind of more entry-level positions through collective bargaining, they also bring with them wage caps. And so people all start to get the reverse. The longer you've worked at a place, you think that the longer you work, the more likely you are to be promoted. Your wage should increase if you're doing a good job. You should be rewarded for good performance. These are things that the workforce should want to reward employees for. But if there's caps in place for salaries, if that's part of the collective bargain, right? That you also have to put this cap in, so employers know they're not just continually going to have this ceiling where they can, they can just pay wages higher and higher and higher, and it's never capped. Well, then obviously your employees, it kind of works the reverse, where you don't want to stay in one place and really keep your career there, because you could get capped out on how much money you could eventually earn. Alternatively, you might not be up for a promotion, because in a union, if someone has seniority over you, even if you do a better job or you're more qualified, you would be looked over in the case of a promotion. So there's things like this that if we just focus on the good and we don't look at that, we're not seeing the whole picture.
Interesting. And you mentioned caps as to how much a person could make. Does that mean that they wouldn't be able to receive bonuses above and beyond a certain cap, like production or reward bonuses?
It could be. I mean, it always depends on the specific collective bargaining process that's going on in that company. But my point is when you're in any kind of negotiation or bargaining process, as a whole, right, you're trying to get a certain thing accomplished. And as a result, you do end up helping people by getting that accomplished. But the flip side is you often, there's also people that end up suffering from it as well, right? That's what kind of the basis of a negotiation is. It's never just a win-win. There's always a give and a take, right? And so part of that take harms individuals too. And so it's never just a clear cut, like this is 100% good and we're all going to do better forever and ever, because that's just not, that's all roses and it's great, but it's not reality.
Right. Okay. Got it. And then sticking with the PRO Act, but also tying in the AB5 part of it. So my big problem with AB5 was this ABC test to determine whether somebody was an employee or a contractor, right?
Yeah.
And it basically meant that everybody was an employee in almost a lot of the cases. I mean, truck drivers now were employees. I couldn't play my harmonica at a bar without being an employee. I mean, it was pretty bad, right? So there is talk of an ABC test in the PRO Act. Do you know if that is as stringent as the AB5 one was, or do you know anything about how that would work?
Yeah, so I mean, the PRO Act does essentially seek to have the AB5 three-prong test become a national test. And just kind of like you mentioned a minute ago, what it ended up doing was, whether employers actually could pass the test or not, as far as classifying someone as an independent contractor, the penalties were so steep if they messed up. I mean, to the point where they could actually lose their business, that what happened is exactly what you said. They just ended up classifying everyone as employees because it wasn't worth it to take that gamble and to potentially lose their business if they started making wrong or loose classifications that ended up being misclassifications. And then I know, I'm not sure, we haven't talked specifically about your main issues with the three-prong test, but I know, for example, for a lot of the businesses that I work with and what I've seen them struggle with is it's not super cut and dry, especially prong B, which is the prong where it says that the work isn't customary or ordinary to that business. For some businesses, it's more clear cut as far as whether this would be considered customary or ordinary at this particular business. For other ones, it's a gray area. And unfortunately, there's some workers who would rather have the freedom of the schedule and other freedoms that go along with being an independent contractor. But when they end up in that gray area, especially in prong B, they're classified as an employee whether they actually want to be or not. And so that's just kind of the reality of it.
Yeah, I mean, my problem with the AB5 prongs was that many people who preferred being the independent contractor no longer could be the independent contractor. And I read a story, and I talked about this, was that a lady in Southern California, I think it was San Diego, something like that, had a flower business. She had a small flower shop, and all of a sudden she started getting these big contracts for like big events, right? Like weddings, things like that. And what she used to do was bring in single moms that she knew who needed extra cash. And the day before a wedding on a Saturday, they'd all be there making the bouquets, doing everything. She got sick. She had cancer. She was going through her cancer treatments. And now with the AB5 passed, she wasn't allowed to bring these single moms in on Fridays to come and work to do these big events. And so she basically lost her job. And I'm like, that, and this is a bill that was promoted and targeted as going after Uber and Lyft, because Uber and Lyft were such heathens and they didn't pay their employees and they were terrible. And believe me, I think Uber and Lyft are terrible business owners and I hate their business model and how they treat their employees. But you cannot tell me that this lady who owns a flower shop in San Diego can't bring in a single mom to come in on a Friday and make some extra cash because Uber doesn't know how to pay people. That is what just infuriates the hell out of me, is that small business owners just get shafted on these types of things because they now can't do anything about it. And Uber and Lyft will just figure it out. $200 million through Silicon Valley to get Proposition 22 passed.
Exactly.
But now
Yeah.
this lady still can't bring in a single mom to work on a Friday. The whole thing is just it's just so um it just squashes the small business, and that's my problem with the AB5 wording and the AB5 tests that they have, and that's what I'm afraid of going to a nationwide type of a level.
Yeah, well, your fear is definitely not unfounded, especially for the fact that California did get enough backlash to AB5 that in addition to Prop 22, it also issued this exemption list, right? So
Yep.
it specifically exempts certain professions, so they don't have to follow AB5. Well, the PRO Act doesn't do that. It doesn't offer that exemption list. It doesn't come as a package, right? What it is doing is introducing the Dynamax three-prong test, the A, the B, the C. So right, the A is like you can't be controlled either in fact or through the contract, right? Your employer can't have direct control over you. You can't be engaged in work that's considered customary to that business. And the last one being you almost need to show that you're sort of like an entrepreneurial. Like you have to be somebody who is actually engaged in that business and advertises and markets those services to more than just one company, which is another issue. But that's it. The PRO Act, that's it. They're not giving this list of exempted professions or exemptions that you get with AB5 in California. Now, could it end up coming up down the road? Of course it can, but right now, that's not how it is.
Yeah, and in California, it didn't start with the exemptions, but they quickly realized there was some parts of the state that couldn't work without the exemption, so they kept lengthening the exemptions
Yes,
list.
yes,
300,000 truck drivers. Little League was suspended because Little League coaches weren't employees. I
yes.
mean, just the list just continues, and so that's what really, haunts me about the idea of this. And I've been told since I made the PRO Act videos, the people in the comments, my good friends in the comment section, keep telling me that the ABC test is not part of it, and I'm like, okay, well, let's get somebody on and let's talk about it, because everything I'm seeing says the ABC test is in it. And what it brings me up to is, by the time I really discovered what AB5 was, um, and started researching it, I found some hilarious tweets that California-based freelance writers put out. So before AB5 came out, they were targeting small businesses and
Um,
people that were against AB5, and they were railing on them, just like I get railed on in the comments. And then AB5 gets passed, and they find out that they're not allowed to write more than 30 articles for a
yes,
magazine.
good
And
point.
then the tweets start coming out like, what guys, what do we do? What do we do about this AB5 thing? And it's the same people that were attacking before it passed, and now they're freaking out because they just lost their jobs. Half the writers of a lot of big news organizations out there were let go because they were independent contractors, and okay, we don't need you anymore is what they were told. And I just thought that was pretty funny, and I think that the the news organizations and the media that are out there talking about right now how it's not going to kill the freelancers need to go back and look at the case histories of the AB5 stuff.
Sure. Yeah, and I think that is the main problem, right? Is a lot of times, especially when you're kind of in this phase where it hasn't been passed yet, and people are just talking about it, and ideas are going back and forth. And the PRO Act has changed. It is different now in 2021 than the 2020 version. But make no mistake, it's they're they really definitely want the National Labor Relations Act to include or incorporate this
Yeah.
this three-pronged test. And that's how they want to be moving forward with their definition, their classification regarding an independent contractor. And there is a definite push for that. If it doesn't come through the PRO Act, it would probably most likely come in a different way. But right now, it is still very much alive as part of that act. I mean, should it pass?
Okay, so the ABC test is a part of the PRO Act, and do you know, are the same ABCs, the three prongs, are they the same worded as in California? Are they different?
It's the same.
It's the same, because I
It's
know
the same
there's
test.
there's talks about how there's other ABC tests in other states, but California's was worded very specifically,
Yes.
um, that I believe was a very poor wording that created a lot of confusion. And so that's what I was curious about with that, is if it's the same ABC type of a test.
It is the same type of a test, yes.
Okay, so let's say, for instance, I work 10 or 15 hours a week for a company, right? And I'm not a full-time employee, but I am doing employment type things and I get paid for my 15 hours that I'm working there. If the PRO Act came through, would that mean that I would have to work a certain minimum number of hours to actually be able to work there or anything like that? I'm just curious.
Well, employers or any workplace can choose to have both part-time and full-time employees. They can have volunteers. So as far as that's concerned, that the amount of hours, it would more depend on what the actual business needed or required from you. I mean, they probably might have some employees already that are just working part-time, so they're not working a 40 or 35-hour work schedule, it may be closer to 15, 20 hours.
Right.
However, it still gets to be a little tricky because, as we talked about earlier, having these gray areas, they look at everything overall, right? And if your actions seem to be that of an independent contractor versus an employee, right? Especially with regard to the work that you're performing, how much control, what your schedule's like and how much control the employer has over you. Well, those things are going to weigh heavily onto how the employer can classify you, regardless of the number of hours that you're working. And obviously, if you're not with someone on a, maybe at least 20-hour basis, then it's going to look like it's more an independent contractor type thing, right? But you don't meet these other parts of the test, and it doesn't matter if they would have been able to before call you an independent contractor. If you can't satisfy all three prongs, then the employer is going to do the safe thing and classify you as an employee.
Yep. And so I will just say, because there's a lot of people hopping on and off the stream, if you have any questions, please ask away. We are going to probably end up doing a second part to this in the next coming weeks to answer more questions. We're on with Ashly Guernaccini. She is the owner of At Cause Law, and she's local to me here, and she has a lot of experience with AB5 and some of the other stuff, which is why I brought her on. I'll bring up an example to you that I got asked by somebody in the comment section of my last PRO Act video. He was asking, he's a wedding photographer, and he was asking if it would affect his business. And I think what he was trying to figure out was if he would have to become classified as an employee to the wedding venue or whatever. Yeah. And I said, no, I don't think so, but it would affect hiring second and third shooters for a big wedding that don't normally work for somebody. Yeah. So in that type of a case, I'm a wedding photographer, I'm a one-man band, or I have a secondary guy who comes out with me one day a week to shoot weddings because, I'm not a full-time business, obviously. Would that limit the ability for me to have a second shooter come in?
It definitely could. It's interesting you bring this example up because I have a personal friend who works in the entertainment industry in California. Now, I'm not her attorney, but she ran into almost the exact same issue where she does costume design, right?
Yeah.
And it's her own company and she runs it, and she has some jobs that are small enough that they can be done just by her. But then she also often gets hired on movie sets and in other areas, and she needs help, whether it's a personal assistant, right? Somebody who can kind of run errands for her, or she sometimes needs to bring on another designer or somebody who can help facilitate whatever she needs to get done to make sure that her job is complete, depending on what the company is asking of her in her contract. And, for years, it's temporary work. She doesn't keep these people employed year round. She's not even typically working year round, right?
Right.
So she would just usually hire people as 1099s. She'd hire them as independent contractors, whether it was her assistant just for that job or whether it was another designer if she had so much work she needed help. But yeah, she was freaking out as well because it is a gamble. You can definitely try to make the argument that these people who you're hiring can still be classified as independent contractors, and maybe you might have some luck, especially when the work is very temporary, but really it's not clear under the test, right? It doesn't really address that temporary aspect. And so even though she was really looking at all the ways that she could classify these workers as independent contractors, at the end of the day, since she does just run a very modest business, probably like your friend,
Yeah.
the photographer, when she tallied up the penalties that could come about, through not classifying them properly, she decided that it just really wasn't worth it for her. And so now she's doing everything that she needs to do on these small jobs to get the unemployment insurance, to make sure if she needs workers' comp, she has it, to make sure all the hiring paperwork is done properly. And really, the interesting thing about it, I know you brought this up too, is the individuals who she's hiring, they don't want to be her employees.
Right.
And they want to work on a bunch of different jobs. And it's kind of one of those things where if they can find someone else who's in the same business who is deciding to take the gamble, they're going to go with them. So, it puts more than one pressure, right? So the first is needing to do, a small business needing to conform with everything that goes along with hiring employees, because it can be a lot more money and more burdensome, more time, right? So there's that. But then also sometimes, if somebody truly wants to be a freelancer, truly wants to be able to have that independent contractor status, well, then they're going to shy away from working with you as well.
Mm-hmm. Well, so there's a lot of gray area on that one then.
Definitely, for sure.
Yeah. Okay. Well, I asked that question for a guy named Charlie, and he's apparently in the chat. He said, "Thank you for asking my question." You're welcome, Charlie.
You're
Subscribe
welcome,
to the channel, buddy. Hit the like button. I read all the comments that we get, and that was one that came up just a day or two ago, and so I was curious about how it would work. Okay, so do you know where, out of curiosity, where AB5 stands right now? Because Prop 22 was passed, the list of exemptions was passed. Do you know if there's any talk about more exemptions coming or it being repealed or anything like that? Just
for AB5?
Yeah.
Yeah. So the interesting thing is, being that I've been working in Florida now since May of 2020.
Yeah.
I haven't followed AB5 much. I was immersed in it for a long time when I was practicing in California as in-house, but I haven't been, it hasn't been a thing for me now, right? Because now my clients aren't California clients. So interestingly enough, knowing that we were going to talk about this, I went online and did some searching, and I was able to find a little bit about people still trying to reform AB5 and bring in more exemptions. But I wasn't able to find, at least, I know I didn't search for a long time, but I wasn't able to find anything solid where there is like anything current actually happening, where there is something up for vote now that would extend that list. Now maybe it's just I didn't find it today, but most of the stuff that I was finding was dealing with the aftermath. But we're going back to 2020. It wasn't so new. It wasn't a 2021 thing.
Okay, so it's still in effect, even though what I found ironic was that Prop 22 got passed overwhelmingly by the citizens, and it got rid of the quote unquote main target of AB5, which is Uber and Lyft. And then the rest of the bill is still there. I'm like, you guys, and this is what people have to understand. And this isn't because of my political beliefs or anything, because everybody in the comments tries to make this about political. It's nothing political. It has to do with the ability for people to decide for themselves where and when and how they want to work and how much money they want to make and all that kind of stuff. So when a bill comes out that's targeting Uber and Lyft, all they're trying to do is get it passed so that everybody's attention is on, we need to hurt Uber and Lyft.
Sure.
Not paying attention to all of the other steps and pieces in its wake. And so I understand that like Uber drivers were really pissed off at how they were being treated. I get it, man. But don't tell me that, the wedding photographer can't have a second shooter on a Saturday who's his best friend because Uber didn't give you your due. You know what I mean?
Yeah, no, that's an amazing point. Because look, come on, companies like Uber, Lyft, the Amazons, the Targets, they're companies that are going to be able to work around the legislation that's passed a lot more readily than these small or even medium-sized companies, right?
Yeah.
So going back to that same thing where you design a piece of legislation because you're trying to prevent a singular evil or what you think is a singular evil. And then the interesting thing is, and Prop 22 is a perfect example of this, right? Where it ends up not, well, I mean, there's Prop 22 didn't just, there's definitely still some things that Uber and Lyft have to follow, of course, but it really lightened it a lot, right? So the whole intention, and I think why it was, so vast and sweeping and how it really did make it so many people had to be qualified as employees. Well, the whole reason was to apply it to these companies who were then obviously able to get Prop 22 passed because of the size of the company and because their ability to have a voice, right, where some smaller companies can't. And then we're just kind of like a dog chasing its tail, right?
Yeah, exactly. And that's what concerned me about the PRO Act is it's called the right to organize. So everybody's like, woohoo! But then it's like, but what's really in there? Because it's not about what it says it's about.
Yeah.
And that's the same thing that happened with the AB5 point is that right there, right? Is it's not really about what it says it's about. And so we have to take a look at it objectively, right? Now, I have a couple of questions here. Charlie asks if there's, he says, if the $600 1099 limit has any effect on AB5. He says, all I need to do is hire some people once or twice a year for just a few hours.
Yeah, so I'm going to preface this by saying I'm not giving legal advice.
The famous attorney line.
Right? But in all honesty, even for like IRS purposes, there's definitely a certain threshold amount that, like the IRS, for example, looks at on 1099s. If, for example, if you're paying a 1099, say even $800 or $1,000 or $2,000, it's not going to be like immediate red flags as if a 1099 is getting paid 25 grand, 30 grand, right? So, so kind of like what I was saying with my friend in the entertainment industry, who I wasn't her attorney either, but it really is just a matter, my opinion, what I like to do, and I'm glad we're saying this because I was going to bring up a list for businesses as well, but for individuals even, look at the IRS factor test as it applies to independent contractors. If you're in California, you definitely want to look at AB5. If you're not in California, right, if you're here in Florida, then you have a luxury right now of that not being imposed on you, right? So I would focus more on what the IRS classifies as an independent contractor, and just keep yourself informed, right? You want to make sure you're aware of state, local, federal laws that are going to affect you, right? And additionally, what the IRS's viewpoint on it is. And as long as you're actually looking at everything and reading it and doing your research, if you're able, you'll be able to clearly see where you fall, because you shouldn't be scared either. Like, I don't want Charlie to be scared, right? You honestly, just as long as you're informed, then it's empowering. And the thing about these things are, and why we're talking about the PRO Act, is they do change year to year, sometimes within a month, several month time span. So it's just good if you are a business owner to constantly be aware of this and make sure you're just diligent in doing your research.
Okay. So maybe the $600 1099 is okay, maybe not, but double check.
Yeah, I mean, I don't think anyone's going to be batting too big of an eyelash over a $600 1099 or somebody who might work on, one photo shoot or something. But then again, I'm going to preface that with, I don't have all the facts. I'm not giving legal advice. I'm just kind of in a general way telling you from my experience what I know tends to carry, even with the factor test in the IRS, some factors are given more weight than others, right? So you really got to weigh the circumstance and look at what the law says and what they're putting more weight on. And are you doing these things or aren't you?
Yeah. And then another quick question was, can you make an individual a legit limited business partner?
You mean just somebody you want to have rather than making them a 1099? Is that?
Maybe. That the question just says, can you make an individual a legit limited business partner? So I would imagine they're saying, can I make somebody a partner?
In the sense that, like limited in the, I guess that without having all the information, I mean, there definitely is, you can have a certain partnership that does include having limited partners. That is
Yeah.
allowed. It's allowed in the state of Florida. Again, you have to go state by state specific.
Yeah.
Lots of times they'll be in entities where they require at least one general partner, but then you can also bring on limited partners.
Yeah.
But like I'm going to say the same thing. Make sure whatever state you're in, you want to look up the different entities that can be formed in your state
Yeah.
and research them. That's actually a really good question because a lot of people just kind of form entities because, you know, they just want to be a corporation or they think that's the right thing to do without actually kind of like looking into it.
Yeah.
And not to get off topic, but I'm glad that question came up because it shows that the person asking it is maybe, you know, at least thinking with what is it a good idea?
They say yeah to circumvent the 1099 issue.
Yeah, and then again, it's kind of like one of those things where my suggestion is always to get legal advice and tax advice, not just legal, not just tax. So talk to your accountant or your CPA and your lawyer, because sometimes something that might be good for tax purposes is not good for you for legal liability purposes.
Right, exactly.
Yeah.
Now
Or
we are
vice
coming
versa.
in. Yeah, we are coming into the last few minutes, so I think at some point we're gonna do a part 2 here. But before we get to part 2, and we do another live on this. By the way, everybody who's still watching, leave comments on the video. We'll hit those up in part 2. Before we end off, what was the main sort of thing that stood out to you as being like a whoa or a red flag when you started looking into the PRO Act and when
Well,
maybe you're not
so
allowed to be an attorney to answer that question.
I have an idea with that. So I actually made a list of what I can foresee being issues
Yeah.
with the PRO Act. I definitely think that's something that we should take up in our part 2
Okay, good.
because it isn't something I want to rush.
So how about
however, in
part 2?
closing,
Yeah, go ahead. In
yeah,
closing.
one thing I did want to bring up, and I'm glad one of the questions sparked my memory to this. I made a list. It's just 3 things, and I already said the one I think with Charlie of what small businesses and individuals really can do if they're concerned about whether to make the move, whether somebody should be classified either for the IRS or for state or federal law, you know, as an independent contractor. And the first one I already went over, right? You just constantly have to monitor federal, state, and local law to stay on top of it. And, you know, anyone can really do this. Google, but you got to watch what you find on the internet. Just kind of like you said, if you're just getting the fact sheets of the individuals who want the bills to be passed, you're only getting one side of it. And you really need both sides. And I mean that, like both sides, even anytime you're doing any kind of research, because like you brought up earlier, this really doesn't have to be party to party, right? I know Democrats and Republicans who I work with in my practice, some are for, some are against. So I think the important thing to do is just to read the facts on both sides in the facts. So watch your sources, you know, and make sure they're legitimate, but really try to stay on top of what's happening because these things have a way of creeping up on us and affecting us. And, you know, we can be kind of caught off guard. So that's number 1, monitoring the laws. 2, if you're in a position where you do currently use independent contractors and you are in a state like Florida's, right? Or even someplace like California, they still might be okay, but you really need to make it a habit to audit your independent contractor agreements as well as your actual practices, right? How you treat your employees and your independent contractors to just make sure, as long as you're doing what it says you need to be doing and you're tracking with that and you're making sure that there's like records of that, then you're going to be fine, right? And part of that is updating your agreements, not letting independent contractor agreements get stale dated 5-6 years, right? And then the last one, which you might not be able to do once the PRO Act passed, but you can do it now, is you really could look at utilizing fair arbitration agreements and class action waivers in some of your either your employee agreements or your agreements that you use with those that you hire. Right now in a lot of states that you are actually allowed to request that your workers go to arbitration with you rather than litigation, which can save both parties time and money. Also, if employers can get class action waivers, then they're more likely to be able to stay in business, even if they do get hit with some penalties, because the cost is a little bit down. And that's still something that's open as of right now, but could change.
I think video number 3 is going to be just about that topic right there.
Yeah. that's the stream after the part.
I was like, wow, wait, I never knew that. That's really interesting. I like that idea.
Yeah,
okay.
We can definitely talk about that more later.
Yeah, that'll be another topic for another evening for sure. Okay, so very interesting stuff. This is a great overview of the PRO Act and the AB5 aspect of it. I really appreciate you coming in. I know you've got another appointment to run to. So like I said earlier, guys, we will do a part 2. Leave your questions and comments down below for Ashly and myself, and we will hit this AB5 and PRO Act topic again. I had never had an intention of being like some person like trying to, talk about yay or nay about some government bill, but I just stumbled on this AB5 stuff, and when my inbox just started loading up with stories from people from California, like A, telling us how their life got screwed by AB5, but B, thanking us for actually talking about it, I was like, I got to do the same thing here, and I want to become a resource for people. So Ashly, I very much appreciate you. I appreciate you coming on. Everybody hit the notification bell. So when part 2 is coming up, you'll get notified as soon as it is coming up. We'll try and update everybody as quickly as we can about when it will happen. And Ashly, again, thank you very much. Is there anything else you'd like to say before we head off?
No, just thank you for having me. I'm glad I was on.
Yeah, absolutely. I'll be on your channel too at some point. How's that?
Yeah, I like that.
Okay, good. Well, everybody out there, thank you all very much. You have a great night. We'll see you next time for part 2. Otherwise, we'll see you next Monday for the usual Monday night live stream at 7 o'clock Eastern time. Stay tuned to the channel and watch the rest of the videos coming out later this week. You have a great night. Ashly, again, thank you very much for coming on. And I'll be sure to link this video into the comment section of everybody who says I don't know what I'm talking about the PRO Act, and that should shut them up. Yeah, right. Okay, good. Good night.
Good night.